If the Supreme Court sides with President Trump, millions of babies born on American soil could be denied citizenship, something that hasn't happened in over 150 years. Right now, 9 justices are weighing a decision that could permanently redefine who qualifies as an American citizen from the moment of birth. Here's what's actually at stake in one of the most explosive constitutional cases in modern history. Welcome to Court Decoded. Today, we cover the Supreme Court showdown over birthright citizenship, examining the constitutional text, the executive order, and why this case could reshape American identity for generations. To understand this case, we must first understand the constitutional bedrock at its center. The 14th Amendment, ratified in 1868, contains what's known as the Citizenship Clause. It reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." These 28 words were written in the aftermath of the Civil War, specifically to overturn the infamous Dred Scott decision and guarantee citizenship to formerly enslaved people. The language was deliberately broad. The framers of this amendment chose the words "all persons born" with intention. They wanted no ambiguity, no loopholes that future governments could exploit to deny citizenship to disfavored groups. For more than a century and a half, this clause has been interpreted to mean exactly what it says. Born on American soil, subject to American law, equals American citizen. But now that interpretation faces its most significant legal challenge since Reconstruction. In the opening days of his second term, President Trump signed an executive order that sent shockwaves through the legal community. The order attempts to redefine birthright citizenship by narrowing who qualifies as subject to the jurisdiction of the United States. Under this executive order, children born in America would no longer automatically receive citizenship if their mothers were in the country illegally at the time of birth, or if their mothers were on temporary visas, such as tourist visas, student visas, or temporary work permits, and the fathers were not citizens or permanent residents. The administration argues this isn't eliminating birthright citizenship. Instead, they claim it's properly interpreting what the 14th Amendment always meant. They contend that children of undocumented immigrants aren't truly subject to the jurisdiction of the United States in the way the Constitution requires. If implemented, this order could affect hundreds of thousands of births annually. Children who, under current interpretation, would automatically be American citizens could instead be born stateless or as citizens of countries they've never seen. The Supreme Court has actually ruled on birthright citizenship before. In 1898, the court decided United States versus Wong Kim Ark, a case that remains the controlling precedent today. Wong Kim Ark was born in San Francisco to Chinese immigrant parents who were legal residents, but under the Chinese Exclusion Act were permanently barred from ever becoming citizens themselves. When Wong Kim Ark returned from a trip to China, federal authorities denied him re-entry, claiming he wasn't actually an American citizen. The Supreme Court disagreed decisively. In a 6-2 ruling, the court held that the 14th Amendment means exactly what it says. A child born in the United States, regardless of the nationality or citizenship status of their parents, is a citizen by birth. The court explicitly rejected the argument that children of non-citizens were somehow not subject to the jurisdiction of the United States. This precedent has stood for 127 years. Every administration, every Congress, and every court has operated under this interpretation. Until now, the Trump administration's legal team presents a sophisticated constitutional argument. They focus intensely on 5 words: subject to the jurisdiction thereof. Their position holds that this phrase has a specific, narrow meaning that has been misunderstood for generations. The argument goes like this: being subject to American jurisdiction means more than simply being required to follow American laws while on American soil. Under this theory, it requires complete political allegiance to the United States. Undocumented immigrants, they argue, have not consented to American political authority. They entered illegally or overstayed visas, demonstrating divided or absent allegiance. Similarly, temporary visa holders maintain primary allegiance to their home countries. The administration points to the original congressional debates surrounding the 14th Amendment, where Senator Lyman Trumbull stated that subject to the jurisdiction meant not owing allegiance to anybody else. They argue Wong Kim Ark was wrongly decided, or at minimum doesn't apply to children of illegal immigrants, a category that didn't exist in large numbers in 1898. Legal scholars and civil rights organizations have mounted an equally forceful defense of the traditional interpretation. Their arguments rest on both text and precedent. First, they point to the plain language of the Constitution. The 14th Amendment says all persons born in the United States, not all persons born to citizens, not all persons born to legal residents, all persons. The exceptions recognized in Wong Kim Ark were narrow and specific: children of foreign diplomats who enjoy immunity from American law, children of enemy soldiers in hostile occupation, and children born on foreign vessels passing through American waters. These exceptions prove the rule. Everyone else born on American soil is subject to American jurisdiction because American law applies to them completely. If an undocumented immigrant commits a crime, they're prosecuted under American law. If they earn income, they pay American taxes. If they have a child in an American hospital, that birth is recorded under American law. That is jurisdiction. Furthermore, the challengers argue that no executive order can override a constitutional amendment. If the president could redefine constitutional text through executive action, the entire structure of American government would collapse. The justices face several distinct legal questions, each carrying enormous implications. First, can an executive order alter the interpretation of a constitutional amendment? The Constitution can only be changed through the amendment process, requiring 2/3 of Congress and 3/4 of state legislatures. If the current interpretation of the 14th Amendment is correct, no president has authority to change it unilaterally. Second, if the court reaches the merits, what does subject to the jurisdiction thereof actually mean? The justices must examine original public meaning, historical practice, and over a century of settled expectations. Third, even if the administration's interpretation had merit, what about stare decisis, the principle that courts should follow established precedent? Overturning Wong Kim Ark would be an extraordinary step, affecting millions of American citizens who have lived their entire lives under the assumption that their citizenship was constitutionally guaranteed. The court must weigh whether the administration's reading of the Constitution is so clearly correct that it justifies upending 127 years of settled law. Beyond constitutional theory, real lives hang in the balance. Approximately 300,000 children are born each year to undocumented immigrant parents on American soil. Hundreds of thousands more are born to parents on temporary visas. Under the executive order, these children would not automatically receive citizenship. Some might become citizens of their parents' home countries. Others could be born effectively stateless, citizens of nowhere, with all the vulnerability that status entails. The immediate practical chaos would be substantial. Hospitals would need to verify immigration status before issuing birth certificates. Social security numbers, passport applications, and enrollment in schools and healthcare programs would all require new verification procedures. Children born to the same parents could have different citizenship statuses depending on when they were born and under what legal regime. Families across America are watching this case unfold, uncertain whether children not yet born will share the same citizenship as their siblings. The court's decision will determine not just constitutional interpretation, but the fundamental identity of millions of American families. The Supreme Court has several options before it. The most straightforward outcome would be striking down the executive order entirely, holding that the president lacks authority to redefine constitutional citizenship through executive action. This would preserve the status quo while potentially leaving open whether Congress could pass legislation addressing the issue. Alternatively, the court could uphold the order on its merits, determining that the administration's narrow reading of subject to the jurisdiction is constitutionally correct. This would represent a seismic shift in American law, potentially affecting the citizenship status of millions and inviting legal challenges to the status of people who believed they were citizens their entire lives. A middle path might see the court invalidating this specific order on procedural grounds while leaving open the underlying constitutional question for future litigation. The justices might also issue a narrow ruling that addresses only certain categories, such as children of undocumented immigrants, while preserving birthright citizenship for others. Whatever the outcome, this decision will echo through American law and American identity for generations. The question of who is an American will receive its most definitive answer since the Civil War. As of now, the Supreme Court continues its deliberations, and the nation awaits a decision that will shape the meaning of American citizenship for generations to come. Lower courts have issued injunctions blocking the executive order's implementation, but the ultimate constitutional question remains unresolved. What is clear is this: the 14th Amendment was written to be permanent and unambiguous to ensure that no future government could create second-class citizens based on the circumstances of their birth. Whether that promise endures depends on how 9 justices interpret 28 words written over 150 years ago. The legal lesson here is profound. Constitutional rights that seem settled can be challenged. Precedents that have stood for over a century can be questioned. The Constitution is not self-executing. It requires constant vigilance, constant interpretation, and constant defense by courts, by citizens, and by the rule of law itself. If you found this constitutional breakdown fascinating, hit subscribe and tap the notification bell. Court Decoded brings you the legal cases reshaping America every week. Drop a comment with the case you want us to cover next.